In family-based immigration, what interviews are eligible for a waiver? Hi, my name is Audra Doyle, and I'm the owner and attorney of Doyle Law here in Atlanta, Georgia. And this question has started popping up because the USCIS has recently begun waiving some interviews for my family-based clients. And so I would like to share with you which cases are eligible to be approved without an interview, and then which cases are definitely going to have an interview. So the first thing you need to know is that your case could be at two different places. For your family-based immigration petition, you could be going all the way through your case with the USCIS, which is here in the United States. Or you could be also dealing with the State Department, where you have to go to a U.S. embassy abroad. Now, if you're dealing with your case inside the United States, only with the USCIS, there will be no consular processing, and it's a family-based immigration petition. That's a lot of ifs. Then your case may be eligible to waive the interview. So let's imagine a scenario. We have a marriage to a U.S. citizen. I submit all of the documents. I submit proof of a valid marriage. Immigration has the choice in the U.S. to decide whether or not to waive that interview and say, no, we don't really need an interview for this client. We feel like this marriage is real. We have no negative facts about this case. We can approve the case without an interview. That's a new thing. But some clients are definitely going to have an interview. I can guarantee it every single time. And those clients are family-based cases where there's something to do with the embassy abroad. The embassies abroad is under the State Department. They are under the State Department. You have to go to an interview if your case is dealing with the State Department. So the second scenario that I see is a client that, again, married to a U.S. citizen. They're here in the United States, but they need to file a case called an I-601A waiver case because they have a little problem with their immigration application. Perhaps they crossed the border without permission years ago, and that problem needs to be corrected. When you have an I-601A waiver case filed and pending, I can pretty much guarantee you that once that case is approved, you're going to have to go to the embassy in your home country to have an interview. The Immigration Service cannot waive away an interview for a case like that. So the first case that I mentioned, there's no waiver required, there's no unlawful entry, there's no I-601A, it's just a straight I-130, I-485 application. The second case that I mentioned, there was an unlawful entry, a 601A waiver is required, and that means the embassy is going to be involved. And so when you think, okay, my lawyer told me I've got a 601A, I've got to go to the embassy, the USCIS cannot tell the embassy to waive that interview because those are two different departments. Once the embassy gets a hold of your case, you're dealing with the State Department, and they are not waiving those interviews. So I hope you can see the difference about which cases may get an interview waiver and then which cases are definitely going to have an interview. And these days, it's really hard to tell, even with my nice clean cases, I-130, I-485, no waivers required, no I-601A required. Some of those cases will still be asked to come in for an interview at the local office. So I always tell my clients we should expect an interview, but if immigration says we don't have to go, that is a nice, happy surprise. If you have any questions about this or you need assistance with your case, don't forget to let us know. Click the subscribe button here on YouTube so that you'll know the next time I post a new video.